the co-chair of Hong Kong 45. She is very well experienced in international arbitration proceedings under various institutional rules, and she also acts as an advocate for these arbitration proceedings. We're very happy to have her, so if I could have you come up, please, and I will switch. Oh, there they are. Sorry. Okay, I'm gonna go now.
Hello. Hi, everyone. Very happy to see all of you here. And thank you very much to Charlene for the warm introduction and for organizing and inviting us to this amazing event. As Charlene mentioned, my name is Joanne Lau. I'm a partner at ANO's International Arbitration Group. It's a pleasure to be here, and it's a pleasure to be joined by such a distinguished panel. So with me here today in person are Melody. Melody Chan is a partner at White & Case Hong Kong. And we also have here Joseph Chu, who is a partner at Withers, also based in Hong Kong. As a proper hybrid event, we also have panelists who are joining us virtually from different parts of the world. We have Ambassador David Hubner, who's now an independent arbitrator based in the United States of America. And also Ms. Amy Kläsene, who is a partner at Jones Day based in Frankfurt. So thank you to all our panelists for being here. Today's topic is hand in hand, why strong legal and judicial systems strengthen rather than weaken international arbitration. And I think that's a very, very interesting topic because when we talk about international arbitration, very often people describe that as a dispute resolution method that is outside of the court system. And when we talk about pro-arbitration jurisdictions, we sometimes hear of, principles of minimum judicial interference. But at the same time, in practice, situations arise from time to time where parties do need to go to court for judicial assistance, either at the start or during the arbitration or at the enforcement stage. So what we hope to explore today is that interplay between the judicial system and the international arbitration regime, and to see how legal system, judicial system support international arbitration, and together, hand in hand, how they complement each other. So with that, I think we'll launch straight into the panel discussion. We would very much welcome questions, both from our audience here today or for those who are joining us online. I understand there is a Q&A function on Zoom, so please do feel free to submit your questions and we'll try to address them either along the way or towards the end. So let's begin. I want to start, first of all, from the very beginning on choosing the seat. And my first question is for Melody. In your experience, how important is the pro-arbitration stance of a jurisdiction's legal and judicial systems for parties when they are choosing their seat of arbitration? And a related question is, what factors do you consider in determining whether a jurisdiction is pro-arbitration or not?
Thank you, Joanne, and thanks everyone. I should take this opportunity to thank you, the organizer, for inviting me here. It's a pleasure to be here, and it's great to see everybody in conference mode. Turning to Joanne's question, I would first start with saying that it's indeed very important. I'm not just saying it because that's the topic for today. I've actually come with some empirical studies results. So in the latest 2021 Queen Mary University of London White and Case arbitration survey, we've actually taken responses from a lot of people, and that's exactly the question, one of the questions that we've asked them. Firstly, as a method of disputes resolution, it's not surprising that arbitration is one which is very much favored by users when we are talking about cross-border transactions and any disputes arising out of that. Then we delve a little bit further into that. Okay, you're choosing arbitration as your preferred method of dispute resolution. Which seat are you going to choose? And from that results, the survey results shows us that a couple of very well-known jurisdictions, London, Singapore, Hong Kong, all of those are the top jurisdictions in which parties are choosing as the seat of their arbitration. Obviously, then we ask the question, why? Why do you choose these jurisdictions? What's so special about these jurisdictions? It's probably not surprising that the legal trades, the legal system, and in particular the court system that all of these jurisdictions have in common, they have a very strong court judiciary support. So when we then ask our respondents, if we were to change something, what sort of adaptations for other seats that you would be hoping to see to make other seats more attractive? And the answers that we are actually extremely on point for today. 56% of participants, respondents, said they need to have greater support. They want greater support for arbitration by local courts and judiciary. Importance of courts and judiciary. 54% said increased neutrality and impartiality of local legal system courts. 47% says a better track record in enforcing agreements to arbitration and arbitral awards, again, involving the courts. So all of that are very strong factors indicating how important the court, local courts, the judiciary is in terms of arbitration and how it's supported. I think the second question you asked me is what would I consider as a pro-arbitration jurisdiction? I think we need to all step back and think about what arbitration is, and I think Joanne mentioned that as well. It's a way of disputes resolution, but more importantly, it's a privately agreed way of disputes resolution. So if the parties have decided to choose arbitration as their way to resolve disputes between them, they would want to have their choice respected and supported. And as a result, that's the reason why it's very important if the local courts that these parties are at, the arbitration is seated, if they are supported of this choice, if they are supported of any arbitration agreement chosen by parties, it's very important to them. So to me, a pro-arbitration jurisdiction will have to be very strong and very supportive of arbitration in various matters. That would include their willingness to grant anti-suit injunction, whether they will be willing to uphold parties' arbitration agreement, the support these local courts will give in support of arbitration, and lastly, but probably very important, is the stance the court will take when there are applications to set aside awards or when there are applications made in enforcement of those awards. I believe we are going to deal with all of those questions today.
Thank you, Melody. That I think is an excellent start of our discussion. And indeed, it's really interesting to hear so many survey participants touch on legal systems and judicial systems and have desires on what those systems should look like to strengthen international arbitration. One very good point that the survey participants also touch on, as Melody mentioned just now, is they want to see a better track record of local courts in enforcing agreements to arbitrate. And that ties in nicely with my next question, which is one for Amy. I want to get your thoughts, Amy, on what role do the national courts play in upholding arbitration agreements and avoiding proceedings commenced in breach of arbitration agreements?
Thanks very much, Joanne. So I'd like to use the image of the good parent. Courts are, of course, national courts are strong, they're respected, established, and powerful. So what can courts do, or what should courts do for essentially the child arbitration? And I'd say there's really two phases. So at the beginning, like a good parent, the child arbitration will need a lot of support. It's not able to really act on its own at all before we have an arbitral tribunal installed. So at the initial stages, we need attentive care. We need quick and responsive action by the courts to appoint arbitrators where the parties have not themselves appointed, or where the arbitration agreement provides for court appointment. And then there can be appointment difficulties, of course, challenges. Again, then we need swift action to sort of get this child on its feet. And the third way that surfaces is also in relation to arbitral challenges to arbitrators. So we need, again, the swift and decisive support of the courts there. Another way that sort of a young arbitration can really be endangered is by parallel proceedings in courts. So we need courts to dismiss parallel proceedings, to enforce arbitration agreements. And this involves taking really rather a liberal stance towards arbitration clauses, interpreting them liberally, giving them effect, giving effect to the party's desire to have this privatized system of justice. Whether or not the courts go so far as to issue anti-suit injunctions, that's sort of a matter of style. Obviously, we have jurisdictions that will go to that length, in particular some of the common law jurisdictions, and many other jurisdictions, though, that consider that inappropriate. But what happens after the arbitration is sort of initially established, it's got its arbitral tribunal in place, that's where we need that good parent to kind of step back and give the arbitration its independence. In the UNCITRAL model law, we have this sort of limitation on court interference or court support. Interference or support really depends on your perspective. But the court should only act in those enumerated instances where it's required and where it's allowed. And finally, we'll get to these later on in the sessions. If the arbitration needs some help, so with interim measures, then the court should step in and help them, but they shouldn't really micromanage or get involved otherwise. The final point I'd raise is simply none of us are born knowing how to be the perfect parent. It's really learning by doing, and as the times change, in particular, parents also have to keep evolving and learning. And arbitration is a really young discipline. It's evolving very quickly. So there's a steep learning curve. And how does a good parent sort of cope with that? They really should talk a lot to their child. They should talk to the arbitration community, engage in a dialogue. So exactly the type of conference and dialogue we're engaged in today. This is critically important to keep the courts abreast of developments, to ensure they're really understanding some of the complicated concepts such as separability. How do we really deal with that? And again, arbitration clauses, understanding how they work and understanding that they can trust the arbitrators to then take over.
I can just want to add on one point that Amy was talking about, how having a good parent is very important. I think it's also very important to have experienced parents. One of the things, last year, at the end of last year, we were, as a firm, we were doing an anti-suit injunction before the Hong Kong courts. And it's absolutely wonderful that when we go before the court, and the judge is well versed in arbitration, some of the points that Amy talked about, separability, importance of arbitration agreement. In order for us to get our proper relief, we actually do need to have judges who are very well versed in all of those ideas. So I think as a good parent, you need to be kind of experienced as well. And I totally agree with what Amy was saying.
Thank you, Amy and Melody. I think that's the first time I've heard of this analogy, the parent-child relationship. But I think that's a very apt description, and so it's very, very, very interesting. Thank you for that. And Amy also touched on it just now, saying to enforce and uphold arbitration agreements. Sometimes courts need to have a strong hand in knowing they need to stay parallel court proceedings which are commenced in breach of arbitration agreements. But my next question touched on a trickier area where things are less clear-cut. In many jurisdictions, including in Hong Kong, there are discussions from time to time about this tension between the insolvency or bankruptcy regime and the arbitration regime. And it is not often clear what should be properly dealt with by the national court and what should be dealt with by an arbitral tribunal. So I was hoping our panelists could share their views on how this line is or should be drawn. So maybe let me start with David.
Thank you. I'm delighted to be here. I'd like to say, in particular, thank you to the organizers of the event, particularly to my friend Sherlyn. I have to say, Sherlyn is the only person I know who could persuade me to comb my hair and smile into a Zoom camera at midnight here in Los Angeles. I wish I could be with you all in person. If I could slide back briefly to a prior question, I agree with everything that's been said about the importance of selecting the seat. Having been a party as well as counsel and now an arbitrator in arbitration, I would also suggest be very focused on the infrastructure and cost as you select your seat. The most interesting case I encountered as an advocate called for Maui as a seat. The case ended up settling once the parties realized the cost of trying to create the infrastructure for a 4-week hearing on Maui, which is not known for its arbitration infrastructure. In terms of the question posed by Joanne, there's no easy answer on insolvency and bankruptcy. Sometimes it's very location specific. For those of you who are arbitrators, you don't need to know the answer yourself. The best friend of the arbitrator is called the briefing schedule. And if something involving bankruptcy or insolvency arises in your case, the first thing you should do is set a briefing schedule and solicit submissions from your parties. Having said that, I've had 4 of these in recent history, 4 cases in which a party put itself into bankruptcy or insolvency. In 2 of the cases, courts attempted to stay the arbitration. In one of those 2 cases, I proceeded because the court attempting to stay the proceeding was not a court at the seat. In another case, it was a court at the seat, but I did not immediately self-stay. I solicited briefing from the parties, and the tribunal then reached a decision that the prudent approach was to suspend the arbitration pending further word from the parties about the proceedings. The 2 most interesting of the 4, though, involved courts at the seat, but courts which did not immediately attempt to stay the arbitration. You will often find that there is a trustee appointed who makes an appearance through counsel in the arbitration, which then gives you a chance as an arbitrator or a party counsel to have a conversation about how to efficiently structure a process. And in those 2 cases, what ended up happening was the bankruptcy courts deferred to the tribunal on the establishment of a factual record and the reaching of conclusions on points of law other than points of insolvency law, thus reserving to themselves, based on the record established by the tribunal, the right to make decisions on bankruptcy allocations within their legal purview. So in those two cases, it was an interesting hybrid because neither side did an abrupt either attempt to stay or a self-stay once there was a filing.
Thank you, David. I wonder if Melody, you could also comment on this a bit, because I know in Hong Kong we have competing case law, so it's a very, very topical issue here.
Yeah, yes, indeed, Joanne. I think David was kind of talking about from an arbitrator's or from an arbitration perspective how bankruptcy or insolvency proceedings could affect the arbitration. We've actually looked at it from another angle, which is how courts are looking into arbitration agreements. Because obviously the parties, they have agreed to an arbitration agreement and they should have submitted all the disputes between the parties to arbitration. But sometimes creditors would take advantage of the fact that, you know, if to the extent that it's a money debt that's rather straightforward, they would probably take advantage of that and decide to just simply go to the local courts and try and start some insolvency proceedings against the debtor. So in that case, despite the arbitration agreement, they can kind of get around that and just go straight to court and seek a winding up order or bankruptcy order. So we've actually looked into that from different common law jurisdictions. The traditional approach is as winding up insolvency, bankruptcy proceedings. These are class action remedies. And as a result, the court's general approach has been, this is something which is not to be privately agreed with, and as a result, to the extent that there are grounds to proceed with an insolvency or winding up proceedings, they will do so. But I think with the rise of arbitration, and again, with more and more national courts taking a more pro-arbitration stand, the jurisprudence on that has definitely been developing quite a bit. Joanne mentioned the conflicting decisions. There are decisions in Hong Kong where Justice Harris has kind of followed the English approach, saying that we should, to the extent that there is an arbitration agreement, we should respect that and stay or dismiss the winding up petition while we're waiting for the arbitration to be resolved. But then there are subsequent Hong Kong case law which suggests otherwise, and you would need to prove that you actually have a proper dispute before you can refer the matter back to arbitration. The situation in Singapore is kind of similar. Same thing with BVI and Cayman, that with the very popular offshore jurisdictions. It's not very clear. There's a trend that you can or you cannot stay. So again, I think unfortunately we probably has to go to the different jurisdiction, as David was saying, is probably quite jurisdiction specific.
So I guess in Hong Kong, it's watch this space. So it's still a developing area. The next question I want to turn to Joseph, and to change the topic a little bit. Both Amy and Melody touched on interim measures just now as another feature of what judicial systems could offer in support of arbitration. At the same time, I know arbitral tribunals also have the ability to grant a wide range of interim relief. And in recent years, institutions have also introduced emergency arbitrator provisions, which again provide another forum for parties to seek urgent interim relief. So I want to get your views on the following question, which is, despite the ability of tribunals, which can provide interim measures, why is the ability to seek interim relief from national courts in support of arbitration still important?
Thanks, Joanne. I think there are essentially three reasons. I mean, the first reason is, notwithstanding the emergency provisions, emergency arbitrator provisions is available, it's still much quicker to see the relief from the court. I mean, under the HKIAC emergency arbitrator procedure, then you can have the emergency arbitrator appointed in 2 days. They make decision within 15 days. It's already very quick. But courts in Hong Kong are even quicker. In cases where it's really urgent, you can actually get an injunction from the court within 48 hours. So when a party actually is facing the risk of assets being dissipated or evidence vanishing, I think 1 day, 2 days would make a world difference. So that I think is one of the reasons why relief from national court is still important. Another reason is that the relief from national court is actually more directly enforceable. You need to go through a two-step procedure if you want to enforce an order from emergency arbitrator. You need first of all to appoint the arbitrator and then get an order from them. And then with the order, you need to apply to court for leave to recognize the order before you can actually enforce it in Hong Kong. And so this procedure takes time. On the other hand, court actually, if you're able to obtain relief from the national court, those orders can be immediately enforced. So that's the other reason. The third reason is that, given the consensual nature of arbitration, the arbitrator has no power to grant any order against any non-parties. The court is different. I mean, court can grant interim relief against parties that are not to the litigation. So that's another advantage of seeking relief direct from national court rather than from the tribunal or from the emergency arbitrator.
Thanks, Joseph. Yes, that's very on point. I think as arbitration lawyers, very often we think of what can we do in the arbitration, what can we get. But you raised an important point, which is if you want something directly enforceable, sometimes you also have to consider your various options from that angle and to assess whether relief from the tribunal would be sufficient or whether in particular set of circumstances going to a court would be more helpful. And I know one interesting development, which James also touched on in his introduction, is the groundbreaking mainland China, Hong Kong interim measures arrangement, which is also on the topic of interim measures. I don't know if one of you want to.
I was hoping to mention that, but I think James already made a fairly detailed description of it. But I'll just add one point. I think there's some statistics. The arrangement came into force in October 2019. It's now 2 years. It has been used by many users. So there are a total of 53 applications made, and the amount of assets freezed by mainland is huge. It's $2.3 billion US. So that actually is one of the empirical evidence to show the importance of the role of the national court in granting interim relief, because actually we are using it.
Yes. Yeah, also in my practice, I think that has made a real difference in China-related transactions. Picking Hong Kong's seat has this additional advantage now going to PRC courts for interim measures, so a very positive development. Aside from interim measures, national courts also play other role, including in securing evidence for an arbitration. Turning to David, I know there have been some interesting cases in the US on this, and I wonder if you could share more.
Absolutely, thank you. It is important if you're working in a particular seat to track what the current issues are in front of the courts. Here in the United States, there have been 3 particular issues I've been tracking. One of them is of particular interest to me, which is the power of tribunals in cross-border disputes to seek evidence from third parties not in the arbitration. It's been a significant controversy here in the United States We are a federal system divided into 50 states, which are comprised into 11 circuit courts. 4 of our circuit courts have held, including here in California, that a tribunal may not issue subpoenas seeking evidence from entities not party to the arbitration. We have 3 circuits that believe such subpoenas to be appropriate under the Federal Arbitration Act. The U.S. Supreme Court was set to consider the issue this year, but the 2 parties settled their case. So the issue remains open. So if you are planning to arbitrate in a part of the United States, you should be looking at which circuit court your seat is in to see whether there is this ability to subpoena evidence from third parties. Just briefly, there are 2 other important issues that are of larger, I think, applicability and interest. One is the very important issue of whether non-signatories can be made proper parties to arbitration. Here in the United States this year, that issue was settled by our Supreme Court in the GE Energy Power case, holding that, yes, non-signatories can be made by the tribunal parties to an arbitration if there is, under the law selected to be applicable to the arbitration, provisions in that law that would make the joinder of the parties appropriate. Finally, there is always an issue around arbitrability. Whose decision is that? Is that the decision of the courts and the seat of the law, or is it a decision of the tribunal? I have been hoping that that would be finally resolved this year. There is a case, the Henry Schein case, was before the court. The court dismissed the case on a procedural issue unrelated to arbitrability, so that remains open. And in particularly the issue to watch is a provision in the rules of an institution that provides that arbitrability is reserved to the tribunal. If the parties select those rules in their agreement, is the imputed decision on arbitrability through the selection of the rules binding on the parties? Here in the United States, that issue is still an open one because of the dismissal of the Schein case.
That's very interesting, and it sounds like there are some very powerful tools which the U.S. courts could use too. So thank you for that sharing. So just now, the past few questions, we touched on judicial support during an arbitration. I want to move to a slightly different section now. So assuming the arbitration process is done, we reach the enforcement stage of an arbitral award, and we can now look at what judicial support there is. I will go back to you first, Joseph. I wonder if you can share any interesting case law highlighting the court's approach in the enforcement of award, or any cases illustrating limited grounds of refusal of enforcement?
Yes. I will mention one case called C&D. That's a case in Hong Kong. That case, in summary, the court rejected an attempt to set aside an Hong Kong arbitration award on the basis of an alleged jurisdictional point. What happened in that case is this. There's a contract. It contained a multi-layered dispute resolution clause. And one tier said you need to have negotiations between the CFO of the parties before you can actually commence arbitration. Now, no such negotiation took place, and an arbitration was commenced. And eventually, an award was issued against one party called C, and in favor of another party, D. C obviously is not happy, and then applied to the court in Hong Kong to set aside it. And the argument the party made was there was a condition precedent to the commencement of arbitration was not satisfied, and therefore the tribunal does not have jurisdiction to hear the case. Now, under the New York Convention, an award issued by a tribunal is final, and the court would not be allowed to review the substantive merit of the case. It can only set aside an award on very limited grounds. For example, breach of due process or lack of jurisdiction. So the question for the court in that case is whether the failure to satisfy the multi-layers dispute resolution clause is actually deprive the tribunal of its jurisdiction to hear the case. So the court ultimately said no, so basically, and dismissed the application to set aside, and said, look, the failure to satisfy the condition precedents has nothing to do with the jurisdiction of the tribunal. And the court said, it goes to the admissibility of claim. So whether a claim is admissible is entirely a matter for the tribunal to decide. And as a supervisory court, in that case, Hong Kong, basically have no power to review the merits of the case. So that case is interesting in the sense that actually many petitioners in Hong Kong used to assume that if you fail to comply with the multi-layer dispute resolution clause, it's a very important matter, and it actually goes to the jurisdiction of the tribunal. And I've actually seen parties making this, relying on this the same argument, and raise a jurisdictional challenge in the arbitration itself. But this actually clarifies the law, at least in Hong Kong, to the effect that, look, a failure to comply with the condition precedent to an arbitration is important, but it doesn't go to the jurisdiction of the tribunal. And that's the case I want to mention.
And turning to Amy from a civil law jurisdiction, can we hear from you too on whether there are any interesting cases from your jurisdiction on enforcement of award or challenges to enforcement of award?
Sure. I'd like to mention two examples. Harkening back to Joseph just said, I would say there the courts placed substance over form. The two cases that I'm going to address are, I think, where the courts have gone a bit too far and really placed form over substance, and have been holding arbitrations and arbitrators to extremely high standard, and perhaps a standard that is not really realistically achievable. So the first case I'll just mention is from France, which is, of course, a very renowned seat of seat of arbitration. The case involved an ICC arbitration in the automotive sector, SBA versus Volkswagen. The award was set aside in France in 2018, 2019, and went through the appellate process. And the award was set aside. The situation was the following. This involved composition of the arbitral tribunal. One of the party-appointed arbitrator was in a mid-sized national firm. The firm had, and the other side, essentially after the award had issued, read in our local, in Germany, our local legal rag, we call it Juve, that there's a newsletter every day, and they have rankings and a handbook. And we all, of course, try to, it's, sort of like the local version of Chambers or Legal 500. We all try to, provide information to Juve, of course, in an appropriate way. But ultimately what Juve writes, we don't have control over it, and it's not necessarily always perfectly accurate. In any case, the situation was that this arbitrator said he was completely unaware that someone in his firm had billed euro 7,520, so a fairly small amount, for a group company related to Volkswagen. That he was surprised, in fact, when he read about this in Juve as being one of the firm's headline mandates, and that was actually not the case. The court, though, again, held that arbitrator to this extremely high standard and said, even if that was mistaken and there was evidence that it was mistaken, and even though the arbitrator said he was himself completely unaware of that very small representation, the award was set aside. The second case I'll mention involves Germany, another, let's say, up-and-coming seat of arbitration. This involved procedural due process. So this is the so-called AGFA case. It involved, it's a very, very long case. It went on, over many stages for, literally 10 years. Finally, an award issued after many, many difficulties. And that award was set aside in January 21. That was a 2018 award set aside in January 21. The case was technically a domestic case, but its reasoning is, was then immediately applied by parties to an international case. And even though it was domestic in name, the case actually had an international character. Bottom line, what the court did is the court combed through, even though a court is not supposed to revisit the substance, they combed through all of the evidence and the lengthy expert reports and concluded that the arbitral tribunal had failed to consider and, quote, intellectually process a particular aspect of the evidence, and that this failure to have considered and intellectually processed, as evidenced by the words they wrote in the award, right, constitute a violation of the right to be heard. And this is significant, obviously, because if we think of arbitration cases, they're frequently very, very large, very, very complicated, involve reams of expert evidence, frankly, often on a scale that national courts do not face or would be unfamiliar with. And this court was holding that arbitral tribunal to the standard of literally addressing every single point that had been raised in witness evidence or in expert evidence. And as I said, there's currently pending, and we expect the judgment in November of this year, a case Lixel versus AIG. This is one of the a huge post-M&A case, but involving actually a warranty and indemnity insurer. And the same argument was brought, namely that the arbitral tribunal had ignored or failed to consider and intellectually process and express that in the award a certain aspect of the witness evidence. So the lesson learned here is, arbitrators can be held to this extremely high standard and really need to cross every T and dot every I and really go through all of the evidence and, demonstrate or prove that they've intellectually processed it. And I think critically, you could say that that's almost an impossible standard.
Thanks, Amy. I think these examples of successful challenges to awards are like horror stories for arbitration lawyers, parties, and arbitrators, especially when awards enforcement is refused on things which prioritize form over substance. So things which...
If I could just give the conclusion of the horror story, the horror story has not even ended for the arbitrator in the first case that I mentioned. He's namely being sued in France for damages, for having basically caused this award to be overturned, and now having the new costs of a new arbitration. So it really is a horrible story.
Yes. And maybe staying with you, Amy, and I'll be interested in your thoughts to David, is given all of these, do you have any tips or strategies you could share which are available to prevailing parties